Hello and welcome back to another edition of Press Pass on GNAT-TV. I'm Andrew McKeever, the news director at GNAT-TV's News Project. It's a pleasure to have you with us today on Monday, May 8th. Also a great pleasure to be joined by two folks here to talk with us about the recent case involving Fox News and the Dominion voting systems. It's been a couple of news cycles since that case was settled somewhat suddenly. But still, I think a very interesting and important moment in media and jurisprudence, for that matter, and worth talking about and analyzing to see kind of where we all landed and what we might expect next. So here to discuss that with us, we're really pleased to have with us today Stephen Pappas, who's the executive editor of the Barre-Montpelier Times-Argus and Rutland Herald, and also Matt Byrne, who's an attorney with the Burlington-based law firm of Gravel and Shea, and he specializes in media law. Steve, Matt, great to have you with us today. Thank you very much for making the time for this conversation.
It's great to be here.
My pleasure.
Well, as many of you know, Fox News abruptly agreed on April 18th to pay $787.5 million to resolve a defamation suit that was brought by Dominion Voting Systems, a company that produces and sells electronic voting hardware and software, including voting machines and tabulators here in the United States and in Canada, because of the network Fox News' promotion of misinformation about the 2020 election. That monetary award was about half of what Dominion was originally seeking, an award of $1.6 billion, but they also apparently exacted an admission from Fox News that it acknowledged that certain claims that it had made about Dominion were false. So really complicated case, I think, and it certainly had a very surprise ending. I think many of us were expecting a 6 to 8 week long trial. Matt, let me start with you. I wondered if you could kind of explain the settlement a bit to us, and I guess did Fox admit to doing something wrong, or kind of were they trying to fudge the issue a little bit? And I guess also, why do you think they opted to settle instead of going through with the trial and perhaps clearing their name?
Well, the settlement's interesting because the admission was that the statements that were being made on Fox were false, but that doesn't end the case in terms of legal liability for any party, because the requirements under the law are not that you just make a false statement, but that you have certain state of mind when you do that. And in this particular case, the state of mind requirement is that they have made those statements with actual malice, which doesn't mean what it says. What actual malice is that you made false statements knowing that they were false, or with reckless disregard for the truth or falsity of the statement. So there was going to be a really contested trial in front of a jury about Fox's state of mind. And there's two different entities. There's Fox News and then there's Fox Corporation. And so they were going to have a very heated, contested trial about what the state of mind was for these two corporations when there were various news, sources and news personalities that were having pretty lively shows about, what Dominion did and what they didn't do in terms of the 2020 election. So in a lot of ways, I mean, we as the viewing public were deprived of a very interesting trial on a very important issue of First Amendment law. But I think Fox had good reasons, and you never know why somebody settles a case, because they usually don't come out with too much more than a bland statement. But you really don't know inside what Fox was thinking when they decided it was time to pull the plug on the litigation and pay what to you and I is a significant amount of money to get rid of the case. And it could be, public relations issues. It could be an assessment of the liability. It could be any number of things. But they ultimately did pay a significant amount of money, and Dominion decided that it was better to take the money rather than risk a jury trial on this issue of actual malice.
Because I guess it wasn't, even though my understanding anyway is that Dominion was going into this case with a pretty strong case. It wasn't a slam dunk that they were going to win.
No, I mean, it's interesting. I mean, the posturing before you get to trial is a game in and of itself. But, the judge, in a very thorough opinion, went through what's known as a motion for summary judgment, and the standard there is whether there's a dispute of material fact. And in that opinion, the court found that there was no dispute of fact that many of these statements were in fact false. What the court would not resolve on this motion for summary judgment is, again, the state of mind of the people involved in making those statements. So it had pretty much set up a big trial, but I think news reports coming out at the same time that it set up this trial, it also set in place a one last chance to try to settle the case. And there were reports that a mediator was in Europe and came back and tried to get this case settled and ultimately succeeded. So there was a lot of behind the scenes drama going on before the case was officially supposed to kick off.
Well, Steve, let me turn to you. What was your reaction to the case and the outcome? Do you think, at least as far as the media is concerned, do you think this arrived at a good landing spot?
Well, the cynic in me was not surprised that it was settled. Newspaper people tend to be a little grumpy when it comes to these kinds of things. So we, while we weren't expecting it to settle, it didn't surprise me that it did. I agree that it deprived us of what I think would have been a very important public discussion about defamation and about the roles of media and media corporations, for that matter. And we talk a lot about, what we want to be doing and doing the right thing in media, but we often see the bad behavior. So I think in this particular case, people wanted to see somebody held accountable, whether it was Dominion or it was Fox. I wrote an editorial a few days after everything kind of sugared off a bit and suggested that what was sad to me about this case is that it shows, at least to a certain regard, that if you are big enough and you have enough money, you can act inappropriately and then buy yourself out of the doghouse, essentially. And that may be overstating it pretty dramatically, but the perception here was that, as you said, it felt like there was a lot of evidence already kind of playing out that suggested that this was going to hold Fox and the folks who were on Fox accountable for the things that they were saying and the way they were acting, and that just went away. And that piece of it was a disappointment. Not surprising, but I'm really hopeful that this doesn't mean that media moguls just feel like they can say and do whatever they want and be able to write a check and say, well, we can just make it go away at the same time. Readers have certainly been vocal. Our comment section on the articles when we posted them about this particular case have been, as you would imagine, pretty strong on both sides. I would say that there are the more people commenting on this are saying that this was a win for Fox, not for Dominion. That it showed that Dominion was scared of kind of going down this road with Fox. I don't necessarily subscribe to that point of view, but it has been interesting to see at a personal level in our readership in both Central Vermont and in the Rutland market that folks had some pretty strong opinions about how they felt that this really should have played out, because it would have been interesting, and they both wanted to be able to plant their flag and say we won. And I also don't think that this is the end. I think Matt's right. I think that in some incarnation we're going to see this come up again. Maybe not in exactly the same case, but I think you're going to see more cases now coming against Fox News.
Well, of course, lurking in the background is another case involving the Smartmatic Corporation, which maybe we can talk about a little bit before we have to run. So yeah, the story is clearly not over. But Matt, I just wanted to go back to you and maybe have you talk a little bit about what exactly is the actual malice standard. That was established in a case back in 1964, I think, Times versus Sullivan, sort of a landmark case that established the idea that a newspaper or a media organization can print something, and as long as they not knowingly are saying something false or incorrect, if they just weren't complete in their research and they published something that turned out to be wrong, well, that was allowable. And I also recall that you know that there's a very interesting background to the Times versus Sullivan case, growing out of the civil rights movement of the 1960s, and even farther back, a bit of a Vermont connection as well.
Yeah, well, it's very interesting because a lot of people, when they hear the words actual malice, think, well, if you're mean, that's what satisfies the standard. So it's a little bit confusing, but the legal definition of actual malice means when you're talking about public officials or public figures, the person saying the statement, even if it's false, they must say that statement knowing that it's false, or they're reckless, which is a pretty high standard, about its truth or falsity. So it is a pretty speech protective standard. Now, there's a lot of people who've been saying, well, we should reconsider that, including Justice Thomas and Justice Gorsuch, and they want to try to go back to something before then. But the history of it is really interesting because it came up in a case, New York Times versus Sullivan, in the Supreme Court, that formalized that actual malice standard as a matter of First Amendment law. And the case arose out of a lot of the racial conflicts that were going on in Montgomery, Alabama during the 1960s and the Civil Rights era. And the statements that were at issue in that case was about somebody who was a commissioner of the city of Montgomery in an advertisement. They actually didn't even use Sullivan's name. He just said, by implication, they're talking about me. So, like, an example of some of the statements were, like, again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home without killing his wife and child. They have assaulted his person. They have arrested him 7 times. So these are pretty strong statements. And the question I think that the court was really struggling with is how do we have a system where political ideas are open for debate? Because the civil rights, legally, segregation ended in 1954 with Brown versus Board of Education. But as in 1964, there was still some very serious issues about what segregation was going on. So de facto segregation, or segregation in fact, was continuing to exist. And ultimately, what the nation needed to do, and still needs to do, in a lot of ways, is persuade people that this is the right idea. And you can't just force people to change their points of view. You have to debate with them. You have to talk with them. You have to persuade them. So in a political system, from a political science perspective, it's important to have a healthy debate about democratic ideas, not only democratic ideas, but policies. And, defamation is one tool that people use to maintain the status quo. So a lot of the policy considerations that were going on in that case were, well, how do we maintain a system where our democracy is robust and debate is an important part of the system? And what the Fox versus Dominion case says to a lot of the critics of the actual malice standard is, no, this actually does work, because there are people who survive summary judgment and end up getting $787 million in liability paid out because they made what the court found to be false statements. And then there was a jury trial. There was sufficient uncertainty about whether they had said those statements with actual malice. They decided, for whatever reason they had, that they should pay the money. So, the Fox versus Dominion case is a way of saying, no, the actual malice standard actually works. And in the cases where it's deserved, people are paying money out, either in judgments or in settlements.
So, and before we leave that, I guess, does this go all the way back to Matthew Lyon and way back to the Revolutionary War era when Matthew Lyon was briefly imprisoned? Or?
Yeah, no, it actually does. The Matthew Lyon case is fascinating because one of our first congressmen was actually put in jail for making statements critical of the Adams administration, our second president. So, and the statements he made, you know, they were a little coarse, but they were definitely, it was definitely speech about the policies of the president. And you know, back then, there were people who, or the judges in that case, wouldn't recognize the First Amendment defense. And today, that almost certainly wouldn't have standed, you know, pass a motion to dismiss or something like that. So it's interesting how times have changed, but it also shows how important it is, because if you're people who are criticizing the government can end up being thrown in jail, we're very, very much closer to an authoritarian regime or a totalitarian regime, because the, you know, political opposition is the key to democracy, because we don't always have it right? For a while, the majority may think one thing, and over time, people discover that that's the wrong idea, or it should be a different way. And that's why, you know, discussion about political ideas and legal protection for the discussion of political ideas is important to the functioning of a strong democracy that can change its mind and can learn from its mistakes in the past, like we did from the Matthew Lyon trial, right? It would be horrible now if we were convicting people who are opposed to the presidential administrations and throwing them in jail routinely. That just doesn't work very well for democracy. So we've learned from the Matthew Lyon trial. And in fact, the people right after that case voted in a strong Republican, Democratic Republican administration. And for years and years and years, that went on because the people recognized how important free speech was and continued that tradition in Vermont and around the nation.
Another piece of this, and we're kind of nibbling around the edges of it, is that you can have these discussions about the law and defamation and who can say what against a political figure and have the political rhetoric out there, but we start dancing very quickly on the line of censorship, and that's another area we just don't want to. We don't want to go there. We don't want to start testing the waters of who can say what when, and have somebody be the arbiter of who can say what when. And you know, we've seen censorship come up in lots of different ways, and that's just a whole nother piece of this, that if we go to an extreme, because we can't have these conversations right now to sort it out, it's going to get even messier than we could possibly imagine.
Well, Steve, I wanted to kind of follow up a bit on that, because one of the things that occurred to me as this case was sort of gathering steam and heading towards the courtroom was that was there a danger to mainstream newspapers and mainstream media outlets if Dominion had won the case? You know, it seemed like there were all these commentators on Fox News that had said things that they apparently didn't really even believe, if these text messages we saw are to be believed. But would that have opened the door, do you think, a little bit to folks who may not have been perhaps as principled as Dominion, or had the strength in their case that Dominion had, to what might be considered frivolous kinds of libel suits and legal actions just designed to kind of make life difficult or cause economic hardship for legitimate mainstream papers?
I think, like I said earlier, I think that even with the settlement, we're going to see more cases like this start to appear, and this gave the issue a toehold, and it got people's attention because it's Fox News, and there's a very clear division in the nation about, you know, where we want to go in our policies and politics. And, you know, people wanted a victor in this. They didn't want a settlement. They wanted a win. And I personally feel that there are groups in the country who are not going to be satisfied until they get a big win on this, because that then reshapes the entire conversation about freedom of the press and kind of the role of the First Amendment in in how we wear it in the media. And I can't predict it. I certainly have read a lot about how other news organizations were nervous about potential outcomes. But a small town paper like ours, we weren't as concerned about the big picture of it, but we were concerned about at a certain level what it was going to do in the escalation of the rhetoric that we were going to see, and that creates a discord in the community as a whole. And so at a macro level, and Matt can probably speak to this better, at a macro level, there were certainly potential implications at the micro level, where I am dealing with members of the public and my staff are dealing with members of the public. It had an impact even as just a settlement. And like I said, there are folks who want a win here, and they want clear white hats and black hats.
One point I just wanted to hang on for a second. The rules of actual malice, I think, and Matt, I'll maybe go to you here, are different for newspapers, traditional media, and social media platforms. If I'm correct, I mean Facebook, Twitter, Instagram, things can be published there. If they turn out to be false or even malicious, it's not the fault of Facebook or Instagram or Twitter, because they're a pass through. Is that still going to be the case, do you think, going forward after this case?
Well, that's actually a really interesting case that's before the Supreme Court. When you go on Twitter or some other social media platform, you see a lot of really strong opinions. I'll just leave it at that. But some of that stuff is just, obviously false. And the protection that some of the internet social media platforms comes from the Communications and Decency Act from 1996, and it's something called Section 230. That the scope of that protection has finally arrived at the Supreme Court, and there is a case that they're actively considering right now. You'll probably get an opinion sometime in June or early July that will lay out exactly how much protection that section has. So you may, in the next year or so, see some dramatic realignment in terms of the protection that's offered to social media platforms. And the essence of it is that you're just basically an electronic bulletin board, and you're not responsible for what other people say. And as a practical matter, frequently people aren't going to go out and try to find some random person on Twitter and sue them for defamation. It's just not, you're not likely to get any money, and it's going to be an enormous amount of effort. So there is right now a difference in how traditional media and social media are treated, but it may not be as wide a difference after the Supreme Court gets done giving its interpretation of Section 230. So you may see a realignment of some of the print, or you may not. They may decide that, Section 230 does provide this protection for social media platforms. But that case should get decided sometime in June or July, and it'll be interesting to see what the Supreme Court says about that. But the actual malice standard will, if this protection disappears for social media, the actual malice would be the next step, where you would consider whether the statements that were made by people reposting on Twitter would be protected under the actual malice standard. And so then the social media platforms would soon be relying on what the traditional media does to protect, the speech that occurs on their platforms.
One thing that has come up as a result of this case, Andrew, is that we have company-wide been called upon to review libel law and look at some of the recent outcomes and cases, just to make sure that it's fresh on the staff's mind, that they understand what the level of the law is, and also best practices to make sure that we've got a few young reporters making sure that they don't make those potential mistakes where they forget to use allegedly. That's it's a very minor one, but it's a big one, right? Because it can really come back to bite you. But we have, just internally made sure that we're all boning up on our just policies and best practices to make sure that we don't inadvertently put ourselves into a position. And I think that a lot of news organizations around the country are doing the same thing.
Well, we have just a few minutes before we have to run, and I did just want to ask you both a little bit about that Smartmatic case. Matt, is it basically the same kind of situation where Smartmatic is alleging that, hey, they were defamed or whatever by Fox, or is there more to it? I mean, they're asking for $2.7 billion as a settlement, so they must feel really aggrieved, I would imagine.
Yeah, my guess is the damages number is based on things that are independent of what the defamation is, meaning that if they had a larger book of business and a larger book of business went away, that's why the number is bigger. It's not because whatever they're saying was said about them is any worse than what was said about Dominion, but the impact of those statements is bigger because they had a bigger book of business or more clients that decided to turn away from whatever product that they were offering in the election system. So, it's interesting that, liability turns on things that may be completely independent of the speech at issue, but it's true, right? If you don't have a lot of damage because somebody says something about you, that impacts your defamation case or whether you decide to bring it or not. But what's really interesting in these cases is that these were businesses that had, big books of business who ended up being defamed. So they had, I guess, more leverage in negotiating a resolution than somebody who had, just not that much business or not that big of a reputation or something like that. So in that way, defamation it's a little wonky in terms of the incentives that it creates, which is, why it's important to keep in mind, things like the actual malice standard, the fair report privilege, the fair comment privilege, neutral reportage. There's all these doctrines that try to protect our political speech that we as citizens have rightfully allowed to develop in the courts, and the courts are mindful. A lot of judges are very steeped in the political science and in the politics of where they grew up with, so they have an appreciation for the First Amendment. But the most important thing for the freedom of speech is for all of us individually to reaffirm our commitment to working together in a political system and to try, there's a lot of vitriol that's going around in the political system, but fundamentally to our democracy, we have to make a commitment to work with our fellow citizens to try to make this democracy work and to reaffirm our support for democratic principles, including those in the First Amendment. So at the end of the day, the First Amendment's only what we make of it. And, Article 13 of our Vermont Constitution is only what Vermont citizens make of it. And we have to continually reaffirm our commitment to work with people, not only people we agree with, but people we disagree with in this political system, to listen to them carefully, to not marginalize and scapegoat them, but to really work as citizens in a democracy to come to some sort of common government that we all believe in.
Well, we're going to have to leave it there, unfortunately. Boy, I think we could talk about this and some of the ramifications of this case for quite a while longer, but unfortunately the clock says it's time to go. But anyway, I just wanted to thank both Steve Pappas, the executive editor of the Barre Montpelier Times-Argus and the Rutland Herald, and Matthew Byrne, an attorney with the Burlington-based firm of Gravel and Shea. Gentlemen, thank you again very much for making the time for this conversation. I really appreciate it. And thanks to all of you as well who've been watching. I hope you found the program interesting. We'll see you again the next time. Have a great day.